Hey everyone, hope everyone's doing well. Hope everyone is staying safe. Of course, as you know, the governor yesterday just eased some restrictions. Didn't really lift a whole lot, but did ease some restrictions, which will open things up a little bit after April 30th. But in the meantime, I hope everyone is practicing their safe social distancing and washing, which I'm sure everyone is. And just hope everyone's safe. I wanted to talk to y'all today a little bit about power of attorneys. As you know, there are a number of different power of attorneys, and if we have done an estate plan for you, you know that we've prepared a power of attorney for you. But I wanted to go over a little bit about the different types of power of attorneys, the advantages of having a power of attorney, and some of the pitfalls of having a power of attorney. The basic power of attorney that most people are aware of is what we call the general durable power of attorney. Now we say it's general because of the fact that it gives broad powers to the person that you appoint as your attorney in fact. Okay, so it gives them the ability to deal with your finances, make transactions on your behalf, those types of things. But it's very broad powers. The reason why we use durable is because the power of attorney, the powers in the power of attorney survive incompetency. So if you become incapacitated, the power of attorney is still valid and they can still exercise the powers that you have granted to them. So that's why we call it the general durable power of attorney. Now the next power of attorney I want to talk about is what we call the springing durable power of attorney. A springing durable power of attorney actually springs into effect when you become incapacitated. So as long as you're competent, the power of attorney is not valid. You have to be declared incompetent or incapacitated before your attorney in fact has the powers that you grant to them. Okay, so with a general durable power of attorney, the attorney in fact has the powers that you grant to them upon you signing the document. But with a springing durable power of attorney, the power of attorney doesn't spring into effect until you actually become incapacitated. So those are the two differences between a general durable power of attorney and a springing durable power of attorney. Now there is another power of attorney called a specific limited power of attorney. A specific limited power of attorney is basically just that. It is specific to an act, and it is limiting the attorney in fact as to the powers that are granted to them. So for instance, you could give your attorney in fact the specific limited power to sell your property, or the specific limited power to deal with a specific financial account. Okay, so these specific limited power of attorneys are what most banks like. That's what they want to see. One of the pitfalls of a general durable power of attorney is that a lot of financial institutions now are not honoring the general durable power of attorney because it is a third-party drafted power of attorney. Okay, what they want you to do generally is to utilize their specific limited power of attorney. And the reason why they require that is because of liability purposes. They don't know how many of these general durable power of attorneys are out there floating around. I have seen on a number of occasions where a client comes in and they may give the daughter general durable power of attorney. And then 2 weeks later, the son finds out about it. And he says, "Mom, why didn't you give me power of attorney?" Well, she feels guilty So she goes and she drafts another power of attorney and gives it to son. Now there's two power of attorneys out there, okay? And she did not mean to do this, but she just invalidated the first power of attorney. But unless she tells her daughter that she's invalidated that power of attorney, she may go out there and act just like she has the powers, and nobody knows that she doesn't. So there are a lot of liability issues that could arise with general dual power of attorneys, and that's why financial institutions would prefer you to utilize their specific limited power of attorney, because what it does is it says, okay, I'm giving my son, John Doe, the specific power to deal with my accounts at this bank, and limiting that power to dealing with these account numbers, okay? So that the bank then has a specific document that is granting authority to someone to specifically deal with these account numbers, okay? So what that does is that limits the liability of the bank, so they know exactly who has the authority to deal with those accounts. All right. So if you have a general durable power of attorney, it is an essential document in your estate plan. However, do not get a false sense of security thinking that just because you have a general durable power of attorney, it's going to cover everything. Okay. And also know that all power of attorneys, the powers granted to your attorney in fact, cease upon your passing. All right. So the power of attorney dies whenever you pass away. They have no more authority. They're only valid while you're alive, either competent or incompetent. Okay. So with that in mind, just know that when we do an estate plan for you, we will prepare you a general durable power of attorney. However, do not get a false sense of security just knowing that you have a power of attorney is good, but don't get a false sense of security thinking that, well, all financial institutions are going to honor this power of attorney. Just because a financial institution does not honor your power of attorney does not mean that it's not a valid power of attorney. It is legally valid. However, financial institutions are not required by law to honor them. Okay, they can make you exercise or execute a specific limited power of attorney, one that is specific to that financial institution. Okay, so this is just a small synopsis of the three different types of power of attorneys that we deal with most. Of course, there is another power of attorney. It's called a healthcare power of attorney, and that's where you are appointing a healthcare proxy to make healthcare decisions on your behalf in the event that you become incapacitated or that you can't speak for yourself. So, but that is your healthcare power of attorney. The previous three we talked about are generally financial power of attorneys, and they're essential to your estate plan, but just don't get a false sense of security, because you have one. They are good, they are legal, but just know that not all financial institutions will honor them because they want you to execute their specific limited power of attorney. Well, guys, thank you for your time. Again, if you have any questions, if you have any comments, please let us know. We are open. You can contact us at our office number, which is 792-6213. You're welcome to, or you can shoot us an email. So feel free to contact us if you have any questions. If you have any other topics that you would like for us to speak on, let us know. We'll be glad to address those issues. I want to thank everyone for sending in their requests to talk about these power of attorneys. There were a lot of questions out there with regards to power of attorneys, and we wanted to address those questions. So thank you again. Everyone stay safe, and hope y'all have a great rest of the week.